while you were married to the defendant, you became pregnant with your current husband's child. Is that right?
Yes, ma'am.
She got pregnant from another man just 4 months after the wedding. Now the groom won't help with the bills.
I don't blame him.
You don't blame him?
No, I don't blame him.
I don't understand how you don't blame him.
How are you, Mr. Rhodes?
I'm fine. How are you?
Party's on Rhodes versus Rhodes. Step forward, please.
21-year-old Tamara Rhodes is suing her ex-husband, aerospace administrator James Rhodes, 42, for legal fees incurred trying to collect her child's medical bills. He says the child is not his.
Order. All rise. Thank you. Your Honor, this is case number 255 on the calendar in the matter of Rhodes versus Rhodes.
Thanks.
Parties have been sworn in, Judge. You may be seated, ma'am. Have a seat.
Let me see if I understand this lawsuit, Mrs. Rhodes. The defendant had been your husband,
Yes, ma'am.
and you are now divorced.
Yes.
Is this your present husband?
Yes, ma'am.
Why don't you have a seat, sir? According to your complaint, while you were married to the defendant, you became pregnant with your current husband's child. Is that right?
Yes, ma'am.
Your child that was born required a great deal of medical attention in the first 3 months of life.
Yes, ma'am.
The defendant, according to your complaint, refused to pursue insurance claims for the medical bills for that child,
Yes.
the child that wasn't his,
Yes.
forcing you to go out and get a lawyer to pursue the insurance company for reimbursement.
Yes.
So you are suing your former husband for the legal fees that you incurred
Yes.
to get his insurance company to pay for your child.
Yes.
Your Honor, may I clarify?
Sure. Why don't you step up here?
Yeah.
You clarify it, and then you tell me why you didn't pay for your own child's
Very well.
insurance.
She was a dependent under Mr. Rhodes' insurance.
Yes.
Okay, under the fact of the matter is when the child was born, she was still covered under his insurance. And
She was.
She had it was a requirement by the divorce stipulation that she would be
By what stipulation?
the divorce stipulation.
Yes.
Okay, a legal document here that he would maintain her insurance
Let me see it.
and also
Just a second. Just a second. Let me look at it. Absolutely right. This says that the respondent, that's you,
Yes.
shall continue to cover petitioner, that's you, under his health insurance
That's correct.
available through his employer.
That's correct.
Did you continue to cover her?
Yes, I did.
So what's your complaint with regard to him?
Okay, when the child was born, she was still covered under his insurance because she was still married to him legally. I could not even put her under my insurance as a married woman to someone else. I could do it my employer will allow me to do it as a domestic partner once she's divorced. Therefore, when the child was born, under his insurance coverage, she's automatically covered for 30 days. And I have a book that indicates that coverage.
That sounds right to me.
Okay,
So the child is automatically covered for 30 days.
The child went into ICU immediately after birth due to a variety of medical problems. What happened is that once the bills started coming in, his insurance carrier refused to pay them for whatever reason.
Right.
We went through great lengths. We called him. I even personally talked to him on the phone, said that I was Mr. Rhodes, and asked him, well, what can I do? And they said, well, you have to submit an appeal. And that has to be done in writing, and it has to be signed by the member, which was Mr. Rhodes. Now, we called him and talked to him initially and asked him if he would do that. And initially, he seemed like he would be interested in doing that. We set up a meeting and met with him and his significant other, and at that meeting, basically everything came apart. The parties parted ways, and basically, shortly after, our phone was call blocked to his residence, so she could not call him.
What's your last name?
Payetta.
Mr. Payetta, the insurance company declined to pay for the child for the first 30 days.
At that time, yes.
And what you're complaining about is that Mr. Rhodes here You don't have to say anything yet, Mr. Rhodes. Mr. Rhodes here said, I'm not filing any appeals with the insurance company.
That's correct.
And because he said he would not file appeals with the insurance company, you were forced to hire a lawyer.
That's correct.
And the lawyer was able to get the insurance company to pay up.
The majority of the claims. There are still some outstanding.
But the insurance company agreed that they had made a mistake
That's correct.
and that they should have paid.
That's correct.
Well, I suggest you sue the insurance company.
That was a possibility. We talked to the attorney. He said that the chances of that would be very unlikely.
Well, the chances of you being successful against Mr. Rhodes are even less likely, sir. He did what was required of him pursuant to this judgment of divorce. Oh,
did.
yes.
Your Honor, it says that he was supposed to assist in the submission of the
They
claims.
said he had the right to appeal. They wouldn't even
Just a
listen to
second,
me.
just a second. It says that the respondent shall continue to cover the petitioner under his health insurance available through his employer until she is no longer eligible as his spouse and cooperate in the submission and payment of claims and reimbursements.
That's correct.
That's what it says. Now, you submitted the claims.
No, what happens is the hospital submits the claims. They come back denied, and then the hospital sends us a bill and says you have to pay it. Okay, so we called the insurance
Just
company.
a second. You said it was denied. I didn't hear the reason that it was denied. You have that from the insurance company as to the reason it was denied?
They said it because it wasn't his daughter.
It didn't say because he hadn't signed the claim forms.
That's correct.
Right. So he did not do anything.
Your
Just a
Honor,
minute.
we asked him to assist us with submitting the appeals. I even offered to write the letter if he would sign it. The insurance company would not.
Is he trying to talk over me?
Seems like.
I got to write down, sir. I got to write down. I know exactly what you're saying to me. You are saying that the bills were submitted pursuant to this, did not require his signature for it to be submitted because the hospital submits them.
That's correct.
They were disclaiming because the insurance company said since this child was not his, they were therefore not responsible because she was the dependent. That's according to you.
That was their initial story.
Whatever their story was.
Well, their book, the book that they say it's a general services agreement book, which we were able to get them to send us, states that the child is covered for the first 30 days.
So you sued them.
So what we did is I asked them, well, how do I resolve this during a phone call? And they said, well, what you have to do is submit a claim. Actually, they call it in here a grievance procedure if you're dissatisfied with their response.
Their response, you file a grievance procedure.
Well, grievance procedure. That grievance procedure has to come from the member.
And he didn't want to do that.
That's correct.
Just a second. He didn't want to do that. I don't blame him.
Tamara Rhodes wants her ex-husband, James Rhodes, to pay her attorney bill for trying to collect her child's medical bills.
Let me see the letter from the lawyer.
By which one is it?
How are you, Mr. Rhodes?
I'm fine. How are you?
Here it is. This one right here. Your Honor, the issue.
Let me read. I know what the issue is. I'm really smart. Well, this certainly isn't a very strong letter that your attorney wrote to them. He says, additionally, please find a copy of my client's February 24th and March 24th billing statements from this office indicating attorney's fees expended in order to resolve the payment of these claims with your company. I am therefore requesting that you check into the possibility of reimbursement of these fees from your company.
Your Honor?
Look into the possibility of paying? No. You sue him. You sue him. Now,
I acknowledge what you're saying as far as I do believe, truthfully, that the insurance company has a certain culpability towards this whole situation. In fact, maybe a greater percentage. But it was an agreement in Tamara's and Mr. Rhodes' divorce decree that he was to assist her. By the fact that he did not assist her, we had to employ the attorney and incur fees in order to resolve this matter. That is why we feel that Mr. Rhodes is subject to paying some of these attorney fees.
so I'll give it to you one more time, sir. I've read the judgment of divorce. The judgment of divorce provides that he shall cooperate in the submission of claims.
Which he did not do.
You are interrupting me, which is really ticking me off.
Sorry, Your Honor.
No, he did not have to do it in this case because the hospital itself submitted the claims on behalf of your now wife and behalf of your child. The judge's direction pursuant to the judgment of divorce did not say anything about and pursuing all necessary appeals if insurance is declined. Didn't say anything about that. It said submission of claims. He chose not to be involved with the appellate process of the insurance company. The truth of the matter is it was the insurance company that was culpable, and your lawyer or you are free to sue the insurance company for the costs that you incurred in seeing to it that a right decision was ultimately made. Your lawsuit's dismissed. That's all.
Parties are excused. You may step out. Out the back door to your right, please.
Oh, I just hope that Tammy and Jack move on with their own life and take on their own responsibilities instead of trying to make me pay for it.
I was looking after my daughter. You know, someone really sick.
I guess we just have to live with it.
Someday we'd like to have our own baby, and our insurance will pay for that.
I never hit her.
He actually pushed me up against the wall and pulled my hair out.
They had a child, but when they split, he cut off the power and phone.
I mean, you have a child there. Did you give her any notice that you were cutting off her electricity and her phone?
No, I did not.
Well, that's not nice, sir. Do you understand?
Yes, I did.
Perfect.
Parties on Favre versus Powell. Step forward, please.
32-year-old construction worker Eric Favre is suing the mother of his child, charity administrator Rebecca Powell, 31, for expenses while living together. Rebecca is countersuing for lost wages and rent.
Order. All rise. Your Honor, this is case number 274 on the calendar in the matter of Favre versus Powell. Parties have been sworn in. Judge, you may be seated.
We have a lawsuit and we have a countersuit. Let's start with the lawsuit first. Mr. Favre, you and the defendant lived together for a while in a townhouse that you moved into together, according to these papers. So far correct?
So far, correct.
You have 2 children from another marriage or relationship, and you have a child together.
That's correct.
And your arrangement was that you would split all the bills 50-50.
That's correct.
And then there came a time, Ms. Powell, that you believed that either you or you and your children were at risk with the plaintiff being in the house. You called the police and had him removed.
That's correct.
And your lawsuit, sir, says that you wanted to be compensated for the deposit that you jointly put down on the townhouse and for the money that you paid for the furniture that remained in the house.
That's correct.
How much did you spend on all this furniture?
About $1,000.
And how much was the deposit on the townhouse?
$700, I believe. Split that in half would be $350.
Do you have all the furniture?
Yes, I do.
You want to keep all the furniture?
Yes, I do.
$350 is from the townhouse and $500 is for the furniture.
Right.
So that's what you put in, $850.
Exactly.
Now let's get to your countersuit. You indicated to me in your answer, madam, that you were afraid because things had become so hostile in the house.
Exactly.
That, so hostile, between the two of you, they were hostile, that he might assault you.
No,
that's what
he
you said.
did assault me.
Just a second. Well, maybe I read it wrong. Let me see what you said here.
Maybe I
You
wrote
said,
it wrong.
I knew that eventually he would hit me.
And it happened.
Well, that's not what you said in here. You never said that he hit you.
Well, he did.
When?
I have the police reports where they came out. He
When?
actually
What day?
pushed me up against the wall and pulled my hair out of my scalp.
Let me see.
I obtained that from the police department, and what they call that is a CAD call. They didn't do a report on it because they didn't remove him from the premises. But that's the basis by which the judge granted me the restraining order?
No, I understand that this is the basis in which he granted you a restraining order, but you called the police on May 1st, right?
No, I went to the police station on May 1st so that they would escort me to my home to have him removed. He alleged that
Did you ever throw her?
No. What happened, Your Honor, was she was antagonizing me too. She wanted me to hit her because I know and she knows that if I would have struck her, I'd go to jail, I'd lose my job, I'd lose everything I worked for. So I wouldn't do that. She was up in my face. I never hit her. I never hit her. She tried to push me down the stairs while sweeping the stairs. I grabbed her. That's as far as it went. So I wouldn't fall down the stairs. That's as far as it went.
Well, this talks about something. X hit the male with a broom.
That's what happened.
No weapons. That's what this says here. In any event, $170 for reconnection fee for the electricity. Now, Mr. Favre, that I had a problem with. Did you have the electricity and the telephone cut off in the house?
Your Honor, I had everything cut off. Everything was in my name. She was not paying. She didn't pay me on it.
When did you cut it off?
I cut it off, I believe, it was like a week into my stay in the motel.
How did you know she wasn't paying?
I called and I checked. I called the PG&E, I called the phone.
Well, that was a week. You left on May 2nd, sir. So you're telling me on May the 9th, you called and found out that the bill hadn't been paid, so you cut it off?
Yes.
Well, that wasn't nice, sir.
Well,
you have a child there. Did you give her any notice that you were cutting off her electricity and her phone?
No, I did not.
Well, that's not nice, sir.
Your Honor,
you have a child living there. She has 2 young children. What if she had an emergency? According to her, she came home from work and found no phone, no electricity. Is that right?
That's correct.
How much did they charge you to reconnect? Let me see the bills.
They charged me $130 to reconnect the electricity plus the bill, which was about $40. And then the telephone, they charged me the reconnection fees plus that bill.
Just give me what the reconnection fee was.
About $100, roughly.
Let me see.
I don't have that paperwork.
Well, you're suing for it, so how could you not have it? That's what your countersuit is about, the reconnection fees.
It happened, he admits to it.
But I don't know how much it was. Courts don't do abouts. I mean, you would have a bill, Ms. Powell. Your bill would say, this is what it cost to reconnect because it was disconnected. Then I would know how much it was.
Exactly.
I
do not have the bill.
Good. So then I can't consider it because you don't have it. You have to bring your proof to court. $320 for child care expenses for the month of May resulting from the restraining order. What's that about?
He was watching our daughter prior to the restraining order. Once he was removed, I had to get child care.
But you had him removed?
That's right. I had him removed.
Fine. Have you taken him to court for child support?
Yes, I have.
So what happened?
So they granted me child support, and I have not seen a dime of it since May.
Are you under an order for child support, sir?
I'm not under anything for child support that I've received, nothing.
Were you both in court together for child support?
No.
He failed to show up to that hearing.
Oh, well, then you better check, sir. There probably is a warrant outstanding for your arrest. Is there a warrant outstanding for his arrest?
No, there's not.
Well, if he was properly served, then you would have gotten a warrant for his arrest.
He's not working. The court told me that when he finds a job, I am to serve his job with the wage statement to take the money out of his check.
Eric Favre says the mother of his child, Rebecca Powell, owes him for expenses. Rebecca says she had him removed for domestic violence.
How much money in child support are you supposed to get from him?
$697 a month.
Okay. And they entered that order by default.
Exactly, because he didn't show up to 2 hearings on child support.
So, Mr. Favre, where are you currently living?
I currently live in Oakland.
How much rent do you pay?
I pay $540 per month.
And you pay that directly to the landlord?
Yes, I do.
Who's the landlord?
The landlord is Judy Properties.
They also in Oakland?
No, they're in Berkeley, I believe.
And from what source do you get this money to pay your rent?
I've been working odd jobs with construction to pay my rent and to pay my daughter's daycare.
Where was the last job you worked in construction?
Contractors Labor Pool. They're located in Emeryville. I work as a painter and I do construction work.
When was the last time you worked there?
Yesterday.
And how much did you earn?
I worked 7 hours, about $77.
You put this money in a checking account. In order to cash your check, you put it in your checking account?
That's correct.
Where do you do your banking?
Home savings.
Where is the branch?
My branch is on 18th Avenue in Oakland.
Is that right near your house?
Yes, it is.
Very good. You now have sufficient information with which to go back to the family court. Do you understand? Now, Miss Powell, we all make mistakes in life. Sometimes we learn from them, sometimes we don't. You have a child together, so unfortunately you are wedded to him for a while, whether you like it or not. So, Mr. Favre, this is what my ruling ordinarily would be, that I would give you a judgment for $850. I am going to sign an order for $850 prospectively. When we receive communication by mail from Miss Powell that you have appeared in family court pursuant to the summons that had been previously issued to you and commence making regular child support payments, the court will execute on its order for you for your $850. Do you understand what I'm saying?
Yes, I do.
Which means you get your $850 when you start making child support payments in the amount of $697 a month. Do you understand?
Yes, I do.
Perfect. That's all.
Parties are excused. You may step out.
And now the next case.
Parties on Sims versus Sims. Step forward, please.
44-year-old construction worker Kenneth Sims wants his ex-wife, Mary Sims, 38, to pay for his car.
You and the defendant had a rather rocky relationship, according to these papers that I see, and you also have a child together. How old's the child?
He's 21 months.
According to your complaint, Mr. Sims, you decided to leave the house, and you left certain items in the house, and the defendant kept your car. You want to be reimbursed for the things that Ms. Sims, according to you and according to her, threw out. And you want to be compensated for the car because she won't give it back to you.
Yes, ma'am.
When did you start living together? Because that's not clear in this report.
The 7th month of this year, 98.
But you had a relationship before that because you have a child that's 21 months old.
Yes.
What happened in July, sir, when you started to live together?
Well, I'd moved in with her. I was there a few days, and she had a couple of friends come up to me and kind of bodily threatened me. Told me that if I ever did anything that harmed this woman, that they would take care of me. And
had you ever done anything to her before?
Yes, I have a family violence
history.
44-year-old construction worker Kenneth Sims wants his ex-wife, Mary Sims, 38, to pay for his car.
So after her friends came up and said, you ever put your hands on her again, you're going to be chop suey, right? You decided to leave.
Yes, ma'am. I left that morning. I had given Mary $100 for rent for that week. I had left the back door open and went around the back and got my things out quietly in haste of leaving. And I left a few things there that I didn't realize because I was scared.
Where did you go?
Where did I go? I made a phone call to another girlfriend of mine that I had before that's been helping me out, and went and stayed with her.
Where was Miss Sims?
She was at work. I was letting her use my car and gave her my keys so she could have a vehicle to go to work.
Were you working at the time?
Yes, ma'am, I was.
How were you getting to work?
One of the guys there was giving me a ride.
So somebody came by with a car, picked you up with your stuff. What stuff do you say you left behind?
Did you want to see the paper?
Sure.
It was the bowling equipment, belts, buckles, a few things, the items that I had out of moving out in
Bowling
haste.
ball. Why didn't you take a bowling ball with you, sir?
Where we had put the bowling balls was in the cupboard where the towels are, and out of me just looking around the room, I just...
You have his bowling balls?
No, ma'am, I don't.
Where are they?
They were in the trunk of the car.
Trunk of which car?
The car he gave me.
So where are they now?
He got them out of the trunk of the car.
You don't have the bowling balls?
No, ma'am, I don't.
A wrist support. What is that?
It's a support you put on your wrist when you're bowling. When it's for turning the ball over.
Was that in the same place as the bowling balls and the bowling
oh, yes,
bag?
it all fits in the
together.
bag,
You don't have that, do
shoes and
you?
everything.
No, ma'am. I have no use for stuff like that.
A red palm sander. What is that?
It's like a desk sander. It's a vibrating sander that you use to strip varnish or whatnot off.
Where is that?
I don't know, ma'am. Everything of his that I found left at my house was some jeans, a couple pairs of tennis shoes, and a belt. I didn't hear from him for a couple of days. I didn't know if he was coming back. I threw him in the dumpster.
Okay. Well, what about a marine battery? What's that for?
It was a boat battery. It's a marine battery. You can be recharged over and over. And
What'd you leave that for?
It's just something I just overlooked.
Well, you have any of this stuff?
No, ma'am, I do not.
The only thing that you found there was clothes?
Yes, ma'am. He had paged me, and I called him back and told him, look, everything of yours that I found, I threw in the dumpster. If you want it, I'd get over to my apartments and get it.
Now, what kind of car was this?
It's an 84 Cavalier.
You say he gave it to you?
Yes, ma'am.
Tell me about it.
He gave me a signed title.
Let me see it.
I have a copy of the title. The title is dated 7/16/98.
Why did he give it to you?
He had told me, I have a letter from him also that I got in May from him saying that he was going to give me his car and sign the title over to me.
Let me see the letter.
So that I could get to and from work, because I didn't have a vehicle, and getting to work and getting my son to daycare was
Yeah, but why would he
quite
give you
difficult.
Why would he give you a letter for that?
This was the letter he wrote me saying about why he was divorcing me, and he had to stay with his girlfriend Carol so that she would pay for all his bills.
Oh, you mean this was after he left?
Oh, this was, yes.
This letter was after he
left?
left?
This was before he moved, before he came to my apartment.
Just a second.
That was in May.
Oh, this was in May?
Yes, and he divorced me in June.
And
he wanted to move
and then
in
he
with
wanted
me
to
in
move,
July.
Then he moved back in July.
Exactly, that's what he wanted.
Oh, just a minute. May, he was with the girlfriend.
Yes, ma'am.
June, he divorced you.
Yes, he got it annulled.
He got your marriage annulled.
Mm-hmm.
July, he changed his mind. He wants back in.
Exactly.
Did you see this letter? Did you write this letter?
Well, I'd like to see it.
Sure.
That's a copy of the letter the original. I'd made these copies on my fax machine at work and sent the original to his girlfriend so that she would know what he was writing and saying.
Yes, I wrote
Nifty.
this.
So you told her you were going to give her the car?
Yes, I did.
Good. Then we have no problem. So she doesn't have any of your stuff? You are some charmer, boy, let me tell you. So now that I've determined, Mr. Sims, that she doesn't owe you for the car because she told you you were going to make a gift to her of the card and you just followed through by signing over the title to her, you say it's forgery, I'm sure, right?
Oh, no, that's my signature.
Oh, good. So that you turned over the car to her?
No.
That's your signature?
I signed the car to sell the car 4 months prior. That signature on that pink slip was signed 4 months before she even seen it.
Okay, so that what you're telling me is when you wrote her this letter promising your car, you were planning on selling it to somebody else?
Oh, yeah. Oh, no. Yeah, when I wrote her the letter, it was already, yes, to be sold.
Oh, you are dull. I don't know what you're like at all. I have no idea. Why you would let this man back into your life, into your home? I mean, he's in your life because you have a child together.
And I let him back in my life time after time again for my son.
Just a second, you're not
This
giving up
man
any...
scares me. He's threatened to kill me.
All right. Well, you picked him.
Yeah, I picked a real winner.
Bad choice.
Extremely bad choice.
Your lawsuit's dismissed, sir. You're not entitled to a dime.
May I have that letter
That's all.
back, please?
Please excuse, you may step out.
I'll take it.
Okay.
He was real hysterical. He was very, very hysterical.
A father fumes over a school's response to his injured son.
Are you telling me that you touched his shoulder and you didn't see that his bone was protruding from his shoulder?
No, ma'am. He just said it hurt. It hurt.
Well, you should take a look at the x-rays. You can clearly see that this bone is sticking out there.
Parties on Duran versus Calvary Baptist School. Step forward, please.
37-year-old auto center manager Bradley Duran is suing his 11-year-old son Bradley Jr.'s school principal, Edward Dial, for his son's broken collarbone. The school says it was an accident and they did everything right.
Order. All rise. Everybody has to rise. Judge, this is number 305 on the calendar in the matter of Duran versus Calvary Baptist. Parties have been sworn in, Your Honor. You may be seated.
Mr. Duran, this is your son, I assume.
That's correct.
The subject of this lawsuit, who was enrolled in the defendant's school. Going to the 6th grade?
Yeah, right at the beginning of 6th grade. That's correct.
Was this his first year at the school?
Second year.
And within the first couple of weeks of school, he was injured.
On the 4th day.
How was he injured?
He was coming from daycare he was coming from his class at the end of school, going to the daycare facility on the same premises. And in between passing with another young man, another one of the kids at school, they just said hi to each other, and Bradley continued to walk to daycare. The other young man came up from behind him, picked him up and threw him into the ground and broke his collarbone.
Did he have any medical treatment at the school?
From what I understand, he did not. I was not even called. I was at work. I only worked maybe 5 to 8 minutes away at the most. And I didn't get a phone call for probably 45 minutes. And at the time that I got the phone call, you know, he was real hysterical. I mean, there was something wrong because he was very, very hysterical. And I said, you know, what happened? What happened? And you know, I couldn't get one thing out of another, so I said, okay, keep him in the office. Keep him in the office, and I'll be there. And they said, we close at 4 o'clock. I said, fine, I'll be there. I was there in 10 minutes. I was there. Went to the office, and he was not in the office right where I asked him to keep him. They sent him back to daycare, went over to daycare, and he wasn't even there. They didn't know where he was. So by this time, I was fuming. And you could tell that he was all hysterical. You could see the bone had already come up and down. I got the x-rays right here, and it shows it big time. It's right there, and he was in a lot of pain.
Let me see the x-rays. You took him to the emergency room first, I assume? This is where you had the x-rays taken?
Yeah, I called my wife. As soon as I took him back to my work, called my wife, and we came back and took him over to the Rancho San Antonio, to the medical center.
Have you seen the x-ray, sir?
No, ma'am.
They said it was almost broke in half.
I see. You're talking about right over here.
Yeah. Said it wasn't a fracture. It was a break.
Well, you certainly could see that through the skin. Show this to Mr. Dial, please. All right. Well, I assume that after this incident at the school, you didn't want your son returning to that school. And what arrangements did you make with the defendant?
I had sent a tuition payment, and I had put a stop payment on that, of course. And you know, we agreed that, yeah, the tuition is no problem. We shouldn't pay for that. I asked for full reimbursement on the books, and so I turned in all the books. I got a signed copy that says they were all returned. They said they could not give me a full reimbursement on the books because he was already in school for 4 days. And I said, 4 days? He's barely even started.
Did you ever get reimbursed for the books?
I got reimbursed for one book. They actually sent me a check for a partial reimbursement, put stop payment on that, and said they weren't going to give me anything.
How much were all the books?
$232.94.
And what was the check that they sent you?
The first check that they sent me?
No, just how much did you get back for the book?
$16.95, excuse me.
What else?
We were also asking for the medical bills to be paid for. And if I break it down, we paid probably close to $600, or we're having to pay about $600 out of pocket.
Well, that's what I want to know. I want to know what you have to pay out of pocket.
Right. Now,
you're suing the defendant for $5,000 for injury that occurred in his school, which means that you have to establish to my satisfaction that there was some sort of negligence on the part of the defendant. Now, I assume you're here to tell me, sir, why there was no negligence on your part.
Well, as soon as we could talk to Brad and find what had happened.
Were you there?
Talk to him. No, ma'am. This young lady was there. I was.
So you weren't there?
No, ma'am.
Step up. Your name?
Laura Brame.
And who are you?
I was his 6th grade teacher for the 3 days he was at school.
Were you the first person from the school that he saw after this injury?
He went to the office after the injury.
Who was in the office?
The secretary, and she sent for me, and I came to the office, and he was upset and yelling and screaming more about the young man that had hurt him, and he needs to get in trouble, and he needs to get in trouble. And I tried to tell him Mr. Dow would take care of it. I would write a note, and he would take care of the problem. And no, he has to get in trouble, and I want him to get in trouble. And I kept asking him also, are you hurt? You want me to call mom? All he said was, my shoulder hurts.
Okay,
and
first clue, my shoulder hurts. So what did you do?
So I tried to calm him down, gave him some ice, took him to...
Just a second. You tried to calm him down, you gave him some ice. What'd you give him ice for?
To put on his shoulder.
Had you looked at his shoulder?
No.
You mean you didn't look at it?
I didn't.
The answer was no, you didn't look at it.
No, I didn't take...
Did the secretary, in your presence, look at his shoulder?
No.
And this was a summer day?
It was yes, September. Yeah.
So it was warm, so he was wearing a light shirt.
I don't know what he was wearing.
Well, it had to be a light shirt. He wasn't wearing a bulky sweater.
No.
Right. And that break clearly...
there was no sticking out or anything.
Did you touch it?
Yes.
Are you telling me that you touched his shoulder and you didn't see or feel that his bone was protruding from his shoulder?
No, ma'am.
Well, you should take a look at the x-rays. You can clearly see that this bone is sticking out there.
So, but he didn't seem to be screaming in terrible pain. He just said it hurt, it hurt.
Bradley Duran wants his son, Bradley Jr.'s medical bills and punitive damages for a broken collarbone. Principal Edward Dial and teacher Laura Brame say they did everything possible.
Okay, so what did you do next?
He was just adamant about Benny has to get in trouble, he has to get in trouble. And so I walked him to the daycare area to calm him down, because by then school was out and people were around the office and stuff, and I thought, well, if I get him out here, I'll calm him down. I went...
What's in the daycare?
It's our after-school program.
Well, there are other children there.
Yes.
Well, that was your next mistake. First mistake was taking him out of an office, which is the office of the building, which you could exclude all other children and keep him in one place, away from other children. Because quite frankly, with that kind of injury, if another child came up to him and bumped him or threw him, he would have been in more serious trouble. So you took him to the daycare center, and what did you do with him there?
I signed him in at 2:30. So the injury happened between 2:10 and 2:15, because I had kept the kids after school because they had been arguing before, and we thought we had it settled. And so I went and I wrote a note to Mr. Dial. I came back to the daycare area to get him, to take him to the office.
Who was in the daycare area when you left him there, other than other children?
The daycare director.
Did you have a conversation with her, or did you just sign him in?
Yes, I told her that he had, his shoulder hurt, and that I would be back in a moment and see, if he was calmed down enough to let me know what, because I had asked him, I said, we'll call mom. Do you want, does it hurt bad enough to call mom? And he wouldn't answer. He just wanted to know that Benny was going to get in trouble.
How old is he?
6th grade.
How old?
I guess 11.
You don't let an 11-year-old make those judgments. You make those judgments. You're the adult. He says, shoulder hurts. You call his parent and you say, his shoulder hurts. Come and get him right away from the office.
Okay. So 5 minutes later, I came back, and he was coming from the other side of campus. He had left the daycare area without anybody's permission. He left the daycare area, got a Gatorade, and came back. He was walking back with a Gatorade in his hand. And so then so he was calmed down enough. I said, let's go call Dad. And I called him on, he was talking to his father on the phone. And his dad must have told him, I can't come right now. And he says, well, you pick me up when I tell you to pick me up. And he was yelling and screaming at his dad, cussed at him, and said, you know, you tell your boss to go to, and wasn't to Walmart down the street, you know, he told him. And then finally, so I said, Brad, you know, I need to talk to your dad. And Dad said, well, I'll be there as soon as I can. I said, he'll be in the office. It closes at 4 o'clock.
What'd you bring him back to the office for?
Because I was taking care of the problem in the office.
How were you taking care of the problem in the office without him being there?
He was in the office.
No. Listen to what you just said to me. You said you took him from the office to the daycare to
cool
sign
down.
him in. Why did you take him there to cool down? That's what I don't understand.
Because you don't understand. You weren't there to see the picture of how upset and irate he was.
So then you keep him isolated. You don't turn him over to another situation. Especially, he's 11 years old. He walks across the campus to get a Gatorade someplace. I mean, that's just not smart. So I could understand. The reason I ask you these questions is because I can understand why Mr. Duran was annoyed enough to take his son out of school and place him someplace else. Because with the procedure that you followed, clearly, in my judgment, was inappropriate. You have an 11-year-old child who's hysterical. You're not expecting him to make good sense out of why he's hysterical. But clearly, he said his shoulder hurt, and based upon the x-rays that I saw, that bone was sticking up right through practically right through his skin. It may not have broken through his skin, but it certainly was protruding. I mean, even Mr. Dial saw that, right, sir?
Saw that.
Absolutely right. Okay. So, mistake. Then his father came.
No, wait.
Me part of it is I'm the boss of my place, so I'm the one that says when to go. Of course.
What does that have to do with the price of tomatoes?
Yeah, I was there immediately.
Go ahead.
So then I sat him down in the office waiting for his father, and then I went over to the daycare and told them, I said, if the office closes, then Brad will be coming over. And then sometime the secretary in the office looked up from her desk a while later, and he was gone to daycare without permission. No one had, no one had said you could go.
You keep talking about this 11-year-old kid getting permission. Somebody's supposed to watch him. What do you mean she looked up when he wasn't?
He just got up and left. He walked to daycare. He didn't, the secretary wasn't, just doing she was doing her work, and she looked up. He was gone.
Somebody's supposed to watch him. He's an injured child. He's an injured child in your care. You're not supposed to act cavalierly. You sign him in with other kids. You tell the teacher to watch him at the daycare. He leaves. He goes and gets a Gatorade. Somebody's supposed to watch him all the time. You have a teacher. You have somebody in the office who you leave him with. She's busy doing other work. He disappears. You act as if it's the 11-year-old's fault.
Bradley Duran is suing his son's school for Bradley Jr.'s broken collarbone.
Miss Brain, let me ask you this question, madam. He seems like a perfectly responsible man. If some official had called him from the school and said, your son has been in an accident, I've checked him over, where he's indicated his shoulder was injured. It appears that there's a bone sticking out. We're going to hold him in the office until you get here. How fast do you think he would have gotten over there? Instead, he gets a call, well, he's hysterical, and he says his shoulder hurts, but we're sending him over to daycare. That was the call. There was no emergency in this call. There's no emergency, and you're telling me the story after you know that he broke his shoulder. I mean, there's difference. I've had a lot of kids. They call me up, right? Adam hit his head. Oh, so tell him to sit down and put ice on his head. Adam hit his head, and I think it requires stitches. Then you're in your car, and you get over there. 2 seconds. You don't wait to put your lipstick on. You run over there. It depends upon the tone and what the person on the other end, the information that the person on the other end is telling you. If they are not in a state of concern, your concern was you felt as if this young man was in more of an emotional concern over the other boy who would hurt him, and that's what you thought his problem was. Well, you turned out to be wrong. His problem was that he broke his shoulder. And you didn't convey that to his father when you spoke to him. That it appeared that he was seriously injured. And it didn't appear that way to you because you never looked. Period. Now, you indicated that there had been some problem with the boys that day.
With several boys.
Was he one of them?
Yes.
Was the other little boy who was involved in this incident one of them?
Yes, I mean, it was just it wasn't fighting, fist fight or anything. It was just mouthy type stuff.
Right.
And
who was there? You? Did you observe
the PE teacher. It was during PE. And then during lunch also.
All right, so during physical education and during lunch, it was reported to you that a small group of boys, how many?
Probably 5 or 6.
Were involved in a verbal altercation.
Mm-hmm.
Is that right?
Mm-hmm.
And this was before he was injured?
Yes.
So what steps did you take as his teacher to ensure that during any free time that they had, these little 11-year-olds were escorted to and from where they had to go?
Well, I talked about it in class.
And you sat down with the class as a whole or with these boys in particular?
Well, both. Outside the door with a few and then inside with the class, letting them know that we're not going to have fighting or whatever on the playground or anywhere, in the classroom or anything.
When you spoke to them individually, was this young man there?
Yes.
What about the other young man who caused the injury? He was there?
Yes.
And what did they both say to you?
They were all talking, all the 5 or 6, well, he did this and he did that and whatever, but I can't remember exactly word for word what was going on.
So then you had your class.
Mm-hmm.
What time was your class over?
At 2:05. And I let them out between 2:10 and 2:15.
And that's when he was injured?
Yes, at the end of class.
Judge Judy will continue in a moment. Want justice? Call 1-888-800-JUDY.
Mr. Dial?
Yes, ma'am.
Your school's responsible. Because you weren't there during all of these things. So I'm very glad you brought your teacher. Let me tell you what my sense is, sir, from what I heard. The teacher of the 6th grade class receives a report from 2 other people in the school indicating that 4 to 5 boys have been involved in sufficient bad behavior towards each other to warrant the reports. She has a class, and outside the class, she says that she spoke, and I'm not even going to ask this young man anything, because she says she spoke to this young man, the other young man, but they're all jabbering, talking, he did this to me, he did that to me, right? So she takes them into class, and then she has a nice discussion, let's all be nice, and we don't fight in this school, that we don't have any fighting. And then they're dismissed, unescorted, by anybody, and within 5 minutes, he's injured. So as far as I'm concerned, that whole problem was taken care of very poorly by your teacher. The next thing that happened was he's injured, he's taken to an office. Nobody examines him. He's 11 years old. And the injury that he had was clearly visible. You, Mr. Duran, is suing for $5,000.
Yes, ma'am.
Judgment is to the plaintiff in the amount of $5,000. That's all.
Thank you.
Parties are excused. You may step out.
Look outside your window one day and you see your dog engaged in fornication.
Yes, ma'am.
His bitch was a lady, so he tracked down the tramp.
You go charging outside.
When the interloping dog saw me, he disengaged and decided that he better hightail it out there.
Isn't it amazing how guys can do that?
All parties on Snodgrass versus Peterson. Step forward, please.
34-year-old teacher Mark Snodgrass says neighbor Judith Peterson's dog may have impregnated his pet Labrador. He wants the veterinarian bills paid. Judith says it wasn't her dog who did it.
Order. All rise. Quiet in the courtroom, please. All rise. Your Honor, this is case number 270 on the calendar in the matter of Snodgrass versus Peterson. Judge, the parties have been sworn in. You may be seated. Ma'am, have a seat.
According to you, Mr. Snodgrass, you have a dog.
Yes, ma'am.
That you keep in the backyard.
Yes.
Female dog. You look outside your window one day, and lo and behold, you see your dog engaged in fornication.
Yes, ma'am.
Can I clean that
Yes,
up?
ma'am.
You did very well, Judge.
trying to find just the right word. With a strange dog.
Yes, ma'am.
What kind of dog do you have?
Actually, I have a yellow lab.
So that's a pretty big dog.
Good-sized dog, medium-sized dog.
And this interloper
Yes, ma'am.
was what kind of dog?
Actually, it was, I'm not sure exactly what kind of dog it was. It was maybe some kind of, maybe an Australian Shepherd, Heeler mix, but it was not a dog that I could identify
But
as a
also a
breed of
big dog.
Probably about a medium-sized dog, maybe similar in size to the dog I had.
Well, dog that evidently picked the right size mate anyway.
Yeah.
So you go charging outside, and what did you do?
Well, actually, the kennel was located on the side of my house, so I was delivering water to my dog when this happened. When the interloping dog saw me, he scaled the fence, and so I went back inside.
Just a second. You mean just like that? He disengaged?
He disengaged.
Disengaged.
He quit his business right there and decided that he better hightail it out of there. And I, at that point in time, kind of said, "Hey,
Isn't it
what are
amazing
you
how
doing?"
guys can do that?
Dogs can do that.
What?
Dogs can do that.
That's right. So after this happened, I did not recognize the dog. I mean, I only saw him for a moment, but I didn't recognize him as any of the dogs that are in my neighborhood. So I went back inside and I saw him kind of skipping down the sidewalk. He seemed pretty happy. And
Pretty happy.
Seemed pretty happy at that point in time.
Okay.
And he was kind of going down the sidewalk, so I knew that I had to figure out whose dog it was. So I grabbed my wife's camera, hopped in her car, and proceeded to just observe this dog, and knowing that at some point in time he would go home.
You followed the boy.
I followed him. And he went here and there, and after about a half an hour or so of following him, he jumped over another fence. He went kind of down a little ditch canal and jumped over another fence. And so I was curious where that was, so I parked my car, walked through this parking lot, and looked over the fence, and kind of started barking and stuff. So that kind of keyed me in that was probably his house. So I went around the block to the front, and of course when I went around to the front, there he was, standing there in his smugness, I guess.
And it turned out to be the home of the defendant.
Yes, it was. Yes, it was.
So you went up to her at that time?
No, ma'am. Actually, what happened was I took some pictures. One of the things that I noticed was that a hole had actually been cut. Even though the dog could scale the fence, a hole had been cut or had been worn through by the dog, so that he had basically free reign of...
Let me see the picture.
Let me find that real quick. He had free reign of the property there, which I felt was kind of an interesting situation.
There is a hole there,
in the
but
side of the fence.
that's a whole other story. So the dog didn't have free reign.
You mean right near the house is where the hole
Yes,
is?
ma'am.
Right, this little spot right here?
Yes. And in one of the pictures that you've been given there, they've actually got a picture of him peeking back through the hole there.
I gotcha. Right over there. Little spot right over here. All right, well, there did come a time when you found out who the owner was.
Yeah, I tried to contact the defendant a little bit later in the day. Actually, I went home and contacted the Humane Society. They told me at that time that what I needed to do was I needed to get my dog to a veterinarian as soon as possible, because at that point in time I wasn't sure whether a successful breeding had occurred or not.
Because your dog was in heat?
Yes, she was. They told me that I needed to get her to a vet right away to have an injection that would suspend any kind of pregnancy or anything, but I needed to get her in real soon. So I took her to the vet. The very next morning, or the very next afternoon, I went to the defendant's home. At that point in time, I had a vet bill for the actual injection, and then the vet required 3 subsequent visits to the vet to do blood work and some things to make sure that no infection or anything had occurred. I rang the doorbell. She came to the door. Her and her dog were inside. I talked to her for just a moment and told her what basically had occurred. She said, that she didn't have any money, and that she wasn't sure if that was the case, and that I was probably just trying to get money out of her or whatever.
And that's where it's at. Now, when did this occur, sir?
The day that the dog was at my house was July 17th. I talked to her on the 18th, which was a Saturday.
Okay. Well, knowing a little bit about the gestation period is 63 days, is that right?
Yes, ma'am.
So you haven't had puppies?
No, my dog ended up not having puppies, which was a blessing.
And what were your vet bills as a result of this?
The vet bills that I have at this point in time come up to $346.35. The injections and the subsequent visits also, because of the breeding being real unsanitary conditions, my dog also contracted a urinary tract infection and some other things, and so she was kind of in bad shape for a while, and so she had to be put on a special diet for a month and some other things.
But your total vet bills are $346.35.
$346.35, yes ma'am.
Mark Snodgrass says Judith Peterson owes him for veterinarian bills after her dog mated with his pet Labrador. Judith says her dog didn't do it.
Now I'll hear you.
Well, most of what he said is true. He did come to my house. I keep my dog chained up in my front yard, not in my backyard. I don't let him have free rein. The hole isn't there so he can come in and out as he pleases. He is chained up and with a stake that goes into the ground 3 foot. When he's not chained up, he was in the house with me. He showed up at my door. I told him no, I didn't know if it happened. I was on a limited income and I wasn't going to pay him. Well, 2 days later, he came over to my house, and I was at work, and he started questioning my neighbor. What did I do for a living? What was going on? You know, did I have kids? All this stuff. And that made me very concerned. I was wondering why this man over this, you know, he had stated too when he left, well, I'm going to take you to court and sue you for a lot more.
Ma'am, if I could real quick, just to clarify something real quick. One of the reasons that I continued to go to the defendant's house was that after this incident, and I talked to her, she continued to let her dog run loose in the neighborhood.
That is not true at all.
As a matter of fact, I have a list of every time that I called and talked to the Humane Society.
I'm not interested in your list. I'm not
There are
interested.
2 other dogs in that neighborhood that look exactly like my dog.
Listen to me. Gentleman comes to your house and tells you that your dog got out of this chained area that you had the dog in, and this is what occurred. To me, a normal response would be, well, let me go out and see whether the chain is broken or anything else.
I did.
My dog was outside chained up. Now, when he came to your house, where was your dog?
He was in the house.
He had just come into the house.
No.
Baloney!
No, he was on the chain when I got home from work that day.
Listen
and
to
I
me.
let him in the house.
Oh,
that's
Ms.
where
Peterson,
I
I
keep him.
don't believe you. I don't believe you. I don't believe that this man, who was very, very careful about getting into his car and following the dog, and the dog, who you said, well, there were lots of dogs that looked like my dog.
Not lots, too.
So there were 2 other dogs, and one of those 2 other dogs left their property, came to his property, did this dastardly deed, and then went home to their property, and he mistakenly saw your dog that was in the house, according to you, in the house.
When he came to my house,
he says, so he was clairvoyant, because he said, well, that looks like a house that probably has a dog in it that looks just like the dog that was outside fornicating with my dog. That sounds stupid to you? Yes. Give me a break. You didn't take good care of your dog and it was running around the neighborhood.
That's not true.
Of course it was true. Aren't you following me? Didn't you understand me? How could he know that a dog that looked just like the dog that was with his dog in the backyard happened to live in your house if the dog was in your house? It doesn't make sense. It's not true. You owe him $346.35. Pay him.
Parties are excused. You may step out.
The defendant had a responsibility to pay for what her dog did.
He still continues to come over to my house and call the dog catcher, even though my dog doesn't live there anymore. He's a jerk.
And now the next case.
Parties on Popovich versus McCauley. Step forward, please.
36-year-old silversmith Frank Popovich says bar owner Corey McCall owes him for medical bills after he swallowed glass from a broken beer bottle. Corey says he found the bottle and the broken glass, so Frank couldn't have swallowed it.
You, sir, own a bar of some sort, is that right?
Yes, I do.
And you were patron in that bar.
Yes.
According to your complaint, sir, you came in, you ordered a beer.
Yes.
And then instead of having the beer put in a glass, which would have been the genteel thing to do, you took a swig, you felt something going in your throat, you looked down at the glass and at the beer bottle, and what did you see?
I saw that there was a piece missing off the lip of the glass, or off the lip of the bottle, and Josh and another friend of mine, they saw that I was having some problem or something was wrong, and I said, yeah, I think I just swallowed a piece of glass. And they took a look at the bottle and they went, whoa, you know, and they called the bartender over, and I said, look, you know, the beer bottle is broken, I think I swallowed a piece of glass. The bartender took the bottle and she replaced it with a new one.
Did you finish the second one?
I didn't finish it. I was drinking it, and I still felt something in the back of my throat, and I was debating whether to go to the hospital right then or whether I should wait a little bit just to see, because I wasn't quite sure. And in the meantime, all of a sudden, I just had this sensation. I went into the bathroom. I began to gag.
Shh, sir, stop playing with things.
I began to gag. I was just kind of dry heaving, and I went, oh, this isn't, there's something there.
Frank Popovich wants bar owner Corey McCall to pay his medical expenses after he was served a beer in a broken bottle.
What kind of surgery did you have, sir?
They put me under, and they basically just scraped the inside of my throat.
Okay, go.
Okay, Your Honor. Well, Mr. Popovich swallowed something that night, but it was not glass. After my bartender took the bottle from him, she kept the bottle, put it in the office, and because he hadn't left the bar till about midnight that night, it seemed fishy to me. So the next morning, I came back into the bar, opened up the bottle cap receptacle, and found the original bottle cap with the chunk of glass missing, stuck to the top of the glass cap. And it fits the bottle perfectly.
All right, so let me take a look at the bottle and the bottle cap that you have.
Now, there was a tiny piece of glass that is missing from there. He says
Just a
that...
second. I'd love to play Sherlock Holmes.
There's glass stuck to the tape, too, as well.
I see it. Well, I certainly see Mr. Popovich. What he's talking about when he says he found a piece of glass in this bottle cap,
Yes.
which was very smart of you to do, sir.
Thank you.
To go around and see if you could find the culprit cap. However, as with all things, if you were to take a magnifying glass and look at this, you will see, because you can feel it if you put your nail over it, that even if you put this piece snugly on top, it's still rough. I find one spot where I can fit my nail in it. Do you know what I'm talking about?
Yes, there's also a piece of glass stuck to the inside tape, though, too.
Yeah, well, that may be. I find one spot where I can actually stick my
That's
nail
about
in it
the
on
size
one
of the piece.
side.
Because it broke off perfectly, Your Honor. The pieces were embedded in the cap perfectly when I found it the next morning because it was undisturbed.
Sir, listen to me. When you break something, it may look like a perfect break. I can put my finger across here and feel several areas where, I'm going to sue myself. I got a piece of glass in my finger. See what I mean?
Yeah.
Do you understand what I mean?
Right.
Little tiny. I did. Little tiny slivers that sliver off even if it seems to be a clear break.
Right.
Right? So, and you can tell that because you injured the judge with your cap, trying to make my point. You have an absolute liability, sir, with regard to this. Absolute. No issue. Your bartender should have taken a look to see that she was serving a bottle that wasn't broken. I mean, you think that this man subjected himself to throat surgery, to having somebody scrape down his throat because he was fooling around? Because he was trying to sue you? It's ridiculous. I mean, they stuck tubes down his throat. You know how uncomfortable that is?
And up
if
my
he was
nose.
just and down his nose, if he was just fooling around trying to make a lawsuit, and if he was trying to make a lawsuit, he would have wanted a lot more than just his medical bills paid.
Then why did he continue to drink at the bar if he thought he had swallowed something after we asked him to leave? To go seek medical attention?
Who knows? You know, sometimes you do it and you feel, you say, maybe I'm imagining things. I really wonder if I swallowed anything. Maybe I did, maybe I didn't, but I do feel something scratchy back here. Maybe it's something, maybe it isn't. I don't want to go to the emergency room. It's an unpleasant thing to go for an emergency room, you know. It's almost as unpleasant as somebody sticking a tube down your nose as somebody sticking a tube up your behind. You know, neither thing is very pleasant, right? So you try to put that sort of thing off, right? I can tell you that. It's not a nice thing to do. He's suing you for $4,100. That's a bargain. Surgery alone, having that kind of surgery alone, is really unpleasant. How do you open this? Who's the bartender? How do you open it? You open it one of those things that's on the bar and you go, boom.
No, it's just a little receptacle thing. You just put in and
You
open
go like
it.
that?
Yeah, just put it in.
No, she said she slammed it down. She said she put it in and she slammed it down.
That's what I've usually seen in the movies, you know. They go,
No, and I did not say that to him at any time.
Judgment for the plaintiff in the amount of $4,100, that's all.
Parties are excused. You may step out. Out the back door to your right.
And now the next case.
Parties on Harper versus Clark. Step forward, please.
Jacqueline Harper claims golfer Ted Clark hit a ball through her window. Ted says it wasn't his ball.
It always amazes me, Mr. Clark, that men can't remember birthdays, they can't remember anniversaries, they can't remember very important moments in their life, but they remember what kind of golf ball they play with. Strange. Anyway, lawsuit is about a golf ball and whose golf ball it was that broke your window. Right?
Right.
So you live on a golf course.
That's right.
Why?
I've asked myself that same question too. I've never lived on a golf course before this.
I always wondered why people would live on a golf course. Seems to me you're outside, you know, want to be puttering in the backyard, sitting by your pool and you're, you know, dodging golf balls.
That's right. I was not aware that, you know, I figured people kept their golf balls on the golf course.
The good golfers do.
Which was
But there are a lot of duffers out there.
assumption on my part.
Okay, so you're sitting in your house and all of a sudden you hear crash. Was this the first crash that you heard? Have you ever had a golf ball break a window or anything else in the
I've
past?
had numerous windows broken by golf balls.
I'd think about a resale if I were you. You know, don't wait
Yes.
until one of these golf balls doesn't do a window, but does your head.
Does my head, exactly.
Okay. And you, Mr. Clark, were playing with a foursome?
Yes, ma'am.
And what did you hear?
What I heard was I heard the ball hit in Mrs. Harper's roof.
Jacqueline Harper claims golfer Ted Clark hit a ball through her window. Ted says it wasn't his ball.
So what did you do?
Well, as we went down the fairway, Mrs. Harper came out of her backyard and said that somebody just broke a window in the front of her house. So I said that must have been me because my ball did hit your roof. So I gave her my name and telephone number and said I would take care of paying for a window to have it replaced. I would pay for it. So I went back down, and when I mentioned this to my golfing partners, we all reflected on it and thought we couldn't understand how it could break a window in the front of her house. So I left my group and went up to Mrs. Harper's house, rang her doorbell, and she came out and I asked if she'd found the golf ball. And she said no, she hadn't looked for it. So at that point I said, well, could I come into your yard and could we find the ball? I said, I'm playing a Top Flight Arrow 3. I have one here that was left in the box from that day. So I went into her yard and we found a ball at the bottom of her flower bed right below the window. It wasn't my ball, and we found another one about another 10 feet away. So I left and I went back and I wrote her a letter that day and basically said, if you find my golf ball, I'll be happy to pay for the window. And about 4 or 5 days went by, then I got a summons to small claims court, and subsequently I got a bill from Mrs. Harper, and she said in the bill that she'd found the ball. So at that point, I went over to her house with a check for, I think it was about $108 the cost of the window. And I told her again I was playing a Top Flight Aero 3. And she said, well, this is a Top Flight XL1. And I said, well, Mrs. Harper, that's not my ball. And she basically said, well, I knew you were going to do this to me. And she went back in her house, and here we are.
You were in the house that day?
Yes, I was.
How many bangs did you hear on your house?
I heard one bang. I heard a window.
You play golf there all the time?
Yes, I do.
See anybody else there hitting a ball at the precise moment you did?
Oh, no, not at all.
So let's talk about common sense. It just doesn't make sense, sir, that at the precise moment that you hit a ball, you hear it hit her house, that another person from wherever hits a ball, and at the precise moment it hits her house and breaks her window, at the precise moment, at the moment that your ball, according to you, hit her roof. Doesn't make sense, right?
No, that doesn't make sense. The ball and the flight of the ball, it doesn't make any sense whatsoever. The flight of that ball could have gotten to a window in the front of her house. What makes some sense is the window could have been broken previously.
Mr. Clark, are you suggesting that this lady who's standing here had a broken window in her house, waited until you happened to hit the roof of her house and said, aha, I got a sucker to pay for the window? Does that sound logical? Look at her, Mr. Clark. What time of the day did this happen, Miss Harper?
It happened at 10:45 in the morning.
When you woke up in the morning, was your window intact?
Yes, the window was intact and had been intact.
Okay. And the window was broken moments before Mr. Clark came up to your house.
Right. I was in the back end of the house and I heard this glass sound breaking. So I went around the house looking to see what broke. By that time, they were down behind the back of the house in their golf carts. So I went out in the back and I said, one of you fellas broke one of my windows. And Mr. Clark comes running up the little back hill there and he says, I did it.
She's suing you for $109.48, which you would agree is the cost of replacing that window. She'll
Correct.
show you a bill. You have a bill?
I have a bill.
Show
I
it to
don't
Mr.
deny that
Clark.
whatsoever.
Right here.
Show it to Mr. Clark.
I have a letter that I wrote to him.
I don't need a
right
letter.
here. I have a letter that he
I would
wrote
just also
to me.
I
add
don't
that
need a letter.
the $109 wouldn't even come out of my own pocket. My homeowner's policy would cover the cost of the window. There's no deductible on damage done
Great.
to other property.
So
this has nothing to do with what
money.
the cost of the window was.
Okay.
That's correct.
So what I'm saying to you is, in order for me to buy your scenario, sir, I have to believe that this lady was laying in wait for just somebody to come and say, I hit your roof, and she'd say, now I got somebody to pay for the window, because I'm sure she has homeowner's insurance too.
Right.
All right? It doesn't sound right. She doesn't look like that kind of
Can I
lady,
just add
although
one
she
other-
stays on a golf course, lives on a golf course, despite the fact that she's
Can I add one other thing?
ducking them all the time. Yes.
Mrs. Harper indicated she was home all morning. That may very well be the case, but I play out there every Saturday morning, and many Saturday mornings I see Mrs. Harper out at that time walking her dog. So whether she was home that Saturday and the dog didn't get to walk, I don't know. But saw her last Saturday. I also saw her the Saturday before around that time walking the dogs.
Listen to me. Listen to me. You hit her house with a golf ball.
Yes.
You acknowledge that.
Yes.
He acknowledges it in writing.
Miss
in
Harper,
this
you're
letter.
winning. Be quiet. Pay the $2. Judgment in this case is for the plaintiff for $109.48. That's
Parties
all.
are excused. You may step out.
Mr. Baker.
Yes. You can call me George.
No, I won't call you George.
Okay.
I'll call you Mr. Baker.
Mr. Baker claims he had a handshake deal to use the phone.
It was in his house.
I don't care whether it was in his house. I don't care if it was in his bedroom. I don't care if it was in his potty. You didn't have an arrangement with her. You had an arrangement with him.
You don't believe that, huh?
Get a life, sir.
Parties on Hobbs versus Baker. Step forward, please.
20-year-old Michelle Hobbs says her friend, self-employed artist George Baker, 33, owes her for a phone bill. George says he paid it.
Order. All rise. Your Honor, this is case number 286 on the calendar in the matter of Hobbs versus Baker. Parties have been sworn in. You may be seated. Sir, have a seat, please.
Miss Hobbs, according to your papers, You had a boyfriend.
Tyson.
What?
Tyson.
Tyson. Is this Tyson?
Yes, it is.
Not your boyfriend any longer?
No.
But you were living together?
Mm-hmm.
And you both wanted a phone. You put the phone in your name?
Yes.
For whatever reason. Mr. Baker was a friend.
Yes, he was.
Who, according to your complaint, was going through some difficult times and asked if he could use the phone occasionally.
Yes, he did.
Okay, so there came a point when you and Tyson separated.
Yes.
And the only thing that you left behind was the phone that was in your name.
Yes.
And you were perfectly comfortable that Tyson was going to pay the bill.
Yes, Tyson and I were very good friends, and I had no problem with leaving the phone there.
And while Mr. Baker was living with Mr. Tyson, Mr. Baker
I wasn't living with him.
He was staying with him periodically.
One day out of a week, every 2 months.
Whatever. While you were there, you used the phone.
That's correct. You don't have to raise your voice at me.
Okay, so you
I
used
can
the
hear pretty
phone.
well.
And you used the phone to make long-distance phone calls.
Yeah, I've made a few.
And your long-distance phone bill was how much?
Originally, we thought it was $350. Since we've gotten more bills and added it up, it has come to $419 and some odd cents.
Okay.
Now.
Can I see that?
Of
Sure.
course you can.
You have the bills?
Yes, I do.
Cool.
Okay. Before you look at those, Mr. Baker, because I'm going to give you time to go over those bills, you indicated, Ms. Hobbs, that when you started to get these bills, you contacted Mr. Baker.
Yes, I did.
And what were the conversations that you had with him?
At first, he had told us that he was using a calling card. Then he told me that there was no problem. He was going to send his brother-in-law down to pay for it by the time that it was due. And none of these events ever occurred.
Now, Mr. Baker.
Yes.
Did you ever have a conversation with Ms. Hobbs indicating that you were using a calling card to make these telephone
No, I didn't. I had a conversation with Tyson that I had used a calling card a few times, and then I told him that instead of using the calling card and receiving the extra charges because he was on Quest or something like that, and I figured my calling card would be more, that I would just call directly and then pay him when they came in.
Okay. So you did have an agreement with Tyson to pay the bills as they came in. Did you, in fact, pay the bills when they came in?
The bills that I felt necessary to pay, yes. Looking at these, I have no idea who some of these phone numbers are.
George has not made one payment to the phone company
Well, the
at all.
first time a payment came in from Tyson, or the phone bill came in, Tyson came to me. This was, first time I believe was in April. If I recall, he came to me and said, your phone bill is $74, something like that. I gave him the money for $74.
Is that correct?
Yes, but that's not what this bill is about.
Okay. That was back in April, so we gave you $74. Stand up here, Tyson. Did you continue to allow him to use the phone?
Yes.
Over the period of months, I've loaned money to him. He's paid back. I've loaned money. He's paid back. I believe it was January or February. I loaned Michelle $160 to get her car fixed, which I've never seen back.
That is untrue. He has never given me any money to fix my car. My car is not in need of fixing. My car is a '92 Saturn.
Mr. Baker.
Yeah.
You were aware of the fact that the phone bill and the phone was in the name of Miss Hobbs.
Yes, I was, but I was also aware that it was in his house, to which she was not a resident of.
Okay, but you understood that it was. I'm asking you these questions, sir, and there's a reason for my asking you these questions.
Okay.
Okay. Now I'm going to get to your defense, because this is not a difficult case, because your defense is most telling. Your defense is that he owed you money.
Correct.
And because
And she owed me money.
she says she doesn't owe you any money.
Well, it's all about who's telling the truth anyway, but she
Right.
owed me $160 for a car.
Mr. Baker, did you pay her directly this $160, or did you give it
I gave it to her directly,
in cash?
in cash, like I normally do.
Excuse me?
When I loan people money, I give it to them in cash.
That's
When I
nice.
get a handshake, that's good enough for me.
Well, you didn't have a handshake with Miss Hobbs with regard to making this bill even. You may have had a handshake with Tyson.
But it was
here
in
to
his
have-
house.
I don't care whether it
And
was
he
in
was
his
the one
house. I don't
using
care if it
it.
was in his bedroom. I don't care if it was in his potty. You didn't have an arrangement with her.
She
You
had
had an arrangement with him. No.
She had an arrangement with him to pay the bill, which means anybody that uses the phone is given permission by him, so he's held liable for it. I can make the agreement with him I don't have to make a tourist.
Look over the bills. Look over the bills.
I'm looking over the bills.
Good. Please look over the
Can I
bills now.
say
No,
one?
I'm going to be quiet. I don't want to confuse Mr. Baker. I want him
Oh, I
to be
don't
able to
get
look over the
confused.
bills.
I can agree with the phone calls to Georgia, Salinas, and Phoenix, Arizona, and Mesa, Arizona.
Tempe.
Yeah, Tempe would be one, but the ones to Pleasanton, I can't agree that all those were mine because both of us know that person in Pleasanton, and neither one of us could have been caller, and I don't have exact times of when I was there.
Most of the calls that I highlighted
Can
on
I
this
see
bill.
that, please?
But-
Go ahead now.
Okay.
He says that you both know this one
Right.
person.
On this bill, the only calls that I highlighted for him were the ones that were made between calls that he had made long distance. And some of those calls we made together, so I didn't highlight all of them and try to be fair, but like I can't recall every single one I made or every single one he made. So I did my best to make it even and only charge or highlight the calls that he made between long distance calls that I know are his.
Michelle Hobbs says friend George Baker owes her for a phone that was turned off. George says her fiancé owes him money.
Evidently, you were a better friend to this gentleman than was Miss Hobbs.
Right.
Is that right?
Yes, very much.
Well, when you started to get these bills that he hadn't paid, what conversations did you have with him?
He originally said that he was going to use a calling card, and then these calls started to show up, and he said, well, I stopped using the card because it's cheaper and I'll pay you for them. The first bill came in at $411.68. I went over it, $311 was his, and $98 and some change was mine, somewhere in that
When you
ballpark.
say you went over it, who did you go over it with?
I went through it myself and highlighted everything that wasn't my call, and I showed it to him. He said, show me the bill, I'll pay you what I owe you.
Now, what did he say he was going to do with the $311?
He told me he was going to pay it. He would go down to a payment center and pay it.
No.
And then he didn't pay it. And then he told us he paid it through his brother-in-law, and he had a receipt. We never saw the receipt. Then he said that, oh, well, it got applied to the wrong phone number. It was one digit off. I'll call and have it taken care of.
Who did he tell this to?
To me. And to her.
And to me.
Okay,
To
but he
us
told
both.
this to you?
Yes.
And he was your friend,
Yes.
really?
But the things that he was saying at the time were plausible. It was a minor mistake from the phone company. It was his brother paid it, so there was a mistake on the number. It could
No, my
happen. It's
brother-in-law.
happened to me before. You know, you make a small mistake, you take care of it. But as it got farther and farther along, the bill became past due, and it went into collections. So now there's a mark on her credit against her because he kept dragging this out, telling us he was taking care of it and not doing it. And that's the only reason I'm upset, is because she trusted me to pay the bill and I trusted him to pay the bill. Other than that, I don't have much of a problem. But she needs to pay a $300 deposit on top of the bill to get a phone now. And I don't think that was exactly fair.
Mr. Baker, where were you living at the time that you were using his phone?
With Jessica, who was my wife,
Okay. And why weren't you using your phone?
because sometimes I was over at his house and sometimes I wasn't getting along with Jessica, and I come over and stay with him, and
Yes.
I use his phone, and I called friends of mine in Phoenix because I do business and stuff in and out of there, and we just got along. But I've loaned money to him all throughout.
I'm not interested in you loaning. If you have loans, then you take care of it a certain way.
Well, you take care of loans. It's basically if you owe me and I owe you, everything cancels out pretty much.
Well, that may
And that's
be-
what we agreed on the handshake.
No, I don't.
basically.
Sir, I said
You
to
don't
you once
believe that,
before.
huh?
No, I don't. A, I don't believe it, and B, you knew very well that the money that was owed on her credit, and therefore, even if I were to
if
believe
I
you,
give the
even
money
if I
to him-
believe you, which I don't, it had nothing. She was not party to that agreement.
No, it doesn't have to be a party. He becomes her attorney, in fact, if she lets him put a place in her house.
Can I say something
Judgment
here?
in this case is for the plaintiff, and the amount requested in the original lawsuit, which is $350. Get a life, sir.
Parties are excused. You may step out. Out the back door to your right, please.
My degree is in criminal law and justice.
He's trying to make me look like I'm some naive thing that doesn't know what's going on. In his big legal background, he knows what's going on.
And I'm just glad it was handled here, not in the federal court, so it doesn't go on my record. Other than that, people can bite me, basically.
And now the next case.
All parties on Greco versus Reese. Step forward, please.
Psychic Joyce Greco claims chromatologist Donna Reese owes her for a failed aura photography business.
Miss Greco, I've read your papers, and what I gather is that you invested $1,000 to go into a joint business venture with the defendant, who also put up $1,000. And your papers suggest that you believe she scammed you out of your $1,000. Is that right?
Yes.
Okay. So tell me what kind of a business venture this was.
This was Aura Photography.
You said Aura Photography. Explain that to me.
Aura Photography photographs the energy around your body. And my job was to interpret the picture, and I do it psychically.
So you're a psychic?
Among other things, I believe we all are psychics. It's whether we choose to use it or not.
So how come you couldn't tell that she was ready to scam you?
Because it would be unethical to read somebody without their permission. And I don't read for myself. I'm paid to read, and I read.
So you're paid to read, but you couldn't do it for yourself?
I don't choose to go through life knowing what's going to happen. And
well, that was a mistake. It may have cost you $1,000.
It may, however.
So tell me about this photography first. How does the photography portion, that's your portion of it, the photography, is that right?
Well, I have a company that manufactures those cameras. It was not part of this venture.
I understand that. Your company manufactures cameras that take pictures of people's...
Of an image of the aura, yes.
What does that look like?
It's a Polaroid picture, it's a double exposure, and then you see the colors around the individual. And we have colorists that interpret it. Occasionally I work with psychics.
How did you meet each other?
I went to have my picture taken at a psychic fair, and she liked my energy so well, she packed up her things before the fair was over, and she came with me and rented a place in my business where I was working. I do massage therapy and hypnotism.
Psychic Joyce Greco claims chromatologist Donna Reese owes her for a failed aura photography business.
So you go to a psychic fair and you take her picture, and you see her aura. And it's your job, after she takes the picture, to look at it and to
interpret what's going on in people's lives. And if they have health issues that we can help them with. And there's a lot of positive things that come through it. We don't do death, doom, or...
I'm dying to see one of the pictures. I assume you're talking about these pictures, the ones with all this funny lights.
Yes.
Ones that look like pictures that I would take, you know, all double exposed and... not lit well. So tell me about the business venture. How did that come about?
Well, the business venture was I was doing readings for her, and she kept complaining about the camera. The camera was so expensive, and I wasn't putting up any money because she wanted to work with me, and I wanted to work with her. So I really believed in the camera, and I felt that, okay, if she's so concerned, I'll leave $1,000 as a bond if I did any damage to the camera, because Harriet and I would go out.
You were using her camera?
Yes.
To do your business?
Occasionally. Alone occasionally. Most of the time it was with her.
So how did this $1,000 come about? As a bond?
Yes. She kept complaining that if anything happened to the camera, she had nothing, that everybody else puts up money, that I don't put up money. And so in good faith, I left her the money. And if she needed to use it for deposits of future events, then she could. But we always paid our expenses right out of that day.
If there was, say, a $100 registration fee for the event or a booth fee, that you paid?
Yeah.
How did you pay it? You each put up half?
We paid it out. We would make money, and we paid it out of our expenses. Right then and there.
You paid it out of your profits?
I paid it out of Aura Enterprises.
Just a second. Now I would turn to you. You just said you paid it out of Aura Enterprises.
Correct.
You paid the expenses out of Aura Enterprises. Well, why did you do that?
She put $1,000 into Aura Enterprises, and I put $1,000 in. I paid for everything up front, and then at the end, I took the expenses off the top, put it back in the company, which was putting it back in, and then I split the profits. Joy continued to work with me after we defunct Aura Enterprises, my ex-business partner and I, and she worked with Colorvision, so there was more monies that was received as well.
But you had another partner in Aura Enterprises, you just said.
Correct.
Nothing that you said in your opening statement suggested to me that she invested $1,000 in Aura Enterprises. What you said was, we entered into a joint venture.
Correct.
Well, why did you take her money, her $1,000, and put it in Aura Enterprises?
I didn't have enough money in Aura Enterprises to go do the shows that she wanted to do.
Just a second. No. You took her money.
Correct.
And invested it in a business that was already ongoing that had another partner.
Correct.
At least one other partner. Now, that wasn't what your arrangement was, either according to her or according to you. You decided what to do with her money. I mean, if you're entering into a joint venture with somebody, then you say, I'm taking this money, and instead of Aura Enterprises, it's going to be Carol Enterprises.
Okay.
The two of us, so that we know exactly what's going on. Because if you had a partner, did you know her other partner in Aura Enterprises?
Can I point?
No, just tell me.
Yes, a very sweet lady.
All right, so you knew her partner.
Yes, and she was there when I left the money in. I did not write a check.
What difference does it make? She's not denying that she gave her the $1,000. Pay attention. But there was no understanding that this money would go into an ongoing operation called Aura Enterprises. You were entering into a joint venture. That would make things very easy to follow. That would make the money trail very easy to follow. You open up a bank account, Carol Enterprises, and you put all the money in there, and so you could take the bank account, and you could take a bank statement and say, this is what we spent, this is what we brought in, and this is your share, and this is my share. That's simple. Instead, you commingled it. Well, that wasn't smart. That's not a business. And then once you commingled it, you said to her, you have no money left. And if you go to fairs and you make profits, and there were, according to you, profits, right? From each show that you did. So if there were profits from each show that you did, she should still have her original investment of $1,000. So here's what we have. We have $1,000 invested in what is clearly a joint venture, not involving any other business, but you engaged in a business, and the business, in fact, was profitable, which means you made money each time you went to a show, over and above the expenses. That's what you say, and you don't seem to deny that. If that is true, then her original $1,000 investment should be intact. The fact that Aura went out of business has nothing to do with that. Judgment in this case is for the plaintiff in the amount of $1,000, that's all.
Parties are excused. You may step out.
I don't feel that it was a personal loan. It was a loan to the company, and the company closed. And that was on the advice of my accountant as well.
I thought the judge looked great. I needed the money. And the fact that I had her sign the agreement with her name, not Aura Enterprises, because it was between her and I. And it breaks my heart.
Parties on Wood versus Beardsley. Step forward, please.
41-year-old accounting clerk Karen Wood says motion picture salesman Alfred Beardsley, 36, agreed to pay her half the fee he received for selling photos of Anna Nicole Smith to a tabloid newspaper. Alfred says they never had a deal.
Miss Wood, you and the defendant are neighbors.
Yes.
You live in the same building complex?
Our buildings are right next to each other.
According to your complaint, the defendant came to you one evening and told you that he had gotten word that some celebrity actress was across the street in the parking lot of this supermarket sitting with somebody and drinking alcohol.
Yes.
And he wanted to borrow some film from you so that he could go and take pictures of her to sell them.
Yes.
Is that right? So you accommodated him, but not only did you give him the film, but you took your camera with film in it, and you went outside to the parking lot and snapped a whole roll of film of this unsuspecting celebrity who was there, having what I assume she hoped was a private moment. Right? And then he went and sold those pictures to one of the tabloids. And you were paid how much?
$1,000.
And you want half of that?
Yes, because we had agreed that whatever money he got from that we would split it 50-50.
Didn't you have a problem with taking pictures of this person and invading her privacy?
Well, actually, she was in a public parking lot, and she was in the car, and they were, putting beer cans outside the car. I mean, it's not that I went on her property and I didn't go into a restaurant or a bar where she was. She was out in the public, And even the clerks of the store, everybody was outside watching her.
Have you ever done this sort of thing before, sir?
I have sold photographs to news organizations and syndicated organizations. I haven't done stakeouts or things of that nature.
But you've sold photographs of celebrities, you mean?
Yes.
Let's address your counterclaim. You're counterclaiming for $5,000 because you say she has harassed you
Yes, Your Honor.
and has filed a false police report against you.
Yes, Your Honor.
So let's get to your counterclaim first.
Well, ever since the photos were taken, she would come to my residence on her lunch hour, after work, every single day.
And say what?
Inquiring as to if
What
I had
happened?
sold the film.
So
I kept her updated as best as I could until she became, annoying me. It was every single day. It was in the evening. It was late in the evening as well. I pitched them to one major tabloid. They had a problem that 4 of the key shots were out of focus.
Not interested in that.
Okay. Anyways, they declined them. I got a second pitch at another major.
I'm not interested in all that. You sold the pictures.
I sold the pictures.
I'm talking about your harassment claim against her for $5,000. So she's coming to your house. She's asking you what happened. You got a pitch. You finally sold the pictures. Harassment.
When we did the agreement for the pictures, all she wanted at that time was a set of prints.
Mr. Beardsley, are you withdrawing your counterclaim for harassment?
No, I'm not.
Then stick to the harassment.
Karen Wood claims Alfred Beardsley owes her for half the money for selling photos of Anna Nicole Smith. Alfred is countersuing Karen for filing a false police report.
Just tell me about what the harassment is.
She would post notes on my door where everyone could see when I wasn't home. She would stand at my door and have a complete conversation with my door. Just saying, Al, this isn't fair. Give me some money, so on and so forth. I finally called her back. I said, Karen, we've got to stop this. We've got to come to some agreement. She said, F you, pay me, and hung up. I called again. F you, just pay me, hung up. 3 more times. F you, pay me, hang up. 20 minutes went by. I'm in my living room. I see 2 police officers walk fast past my apartment. Turns out that she had called 911, told the police department on the dispatch line that I called her stating that I had a gun, that I was coming over to her apartment and I was going to shoot her. In the meantime, she recants her story to the police officer saying, well, I thought
Did she come out at that time?
Oh, her and her mom were out there.
Okay, so she came outside
Yeah.
while the police were there.
Correct.
You remember that?
Yes, I do.
Had you called the police that day?
Yes.
Okay. And you heard her recant the story.
Yes.
What did you hear her say?
She said, well, I thought he had said at one point that he had a gun, and he never actually threatened me with a gun, but I thought he had one because there was a problem a year ago where a silent alarm went off at his house, and the police were pounding at his door at midnight, and he made a statement that he was so scared that he felt like shooting through the door.
What did you told the police when you called 911?
I was walking past his house with my mother and walking the dog, and I yelled, Al, when are you going to pay me the money? Well, he went across the street and called on the payphone, and he said, do you and your mom think that you're smarter than me? I said, Al, why don't you just pay me the money? And he kept saying things and hanging up. Well, I picked up the phone, and I was beginning to call my mom, but I didn't hear it ring, and I guess he had called back, and he said, I'll kill you before I pay you. So I did call 911. They did ask me at 911 if he had a gun, and I said, I don't believe so. I don't see any weapon on him. He just called and said that, what I just told you.
Did you ever say you were going to kill her?
No, Your Honor, I did not say that.
What did you say, sir?
I couldn't get a word in. She kept hanging up on me. And finally I gave up, and she took the liberty of calling the police.
All right. Mr. Beardsley, let me understand this, sir. You got a tip that this actress was across the street.
Correct.
You had no film.
I had no film.
You knocked on her door. She left whatever she was doing in her home, took her camera and her film, and went out to the parking lot. And she was the one who physically took the pictures. Granted, at your direction, you told her what to shoot, where to shoot it, and whatever, and she was the technician. She shot the roll of film.
Correct.
So far, is that correct?
Correct.
And then she also drove you to this tabloid where you went up to make the pitch.
That's incorrect.
Are you telling me that neither she or, according to this, her mother drove you to one of the places?
Her mother drove me to the first pitch.
Just a second.
Okay.
So here we had these people doing the following for you, using their camera, their film, and according to you, if I believe you, her mother took you in her car, drove you to this place, all in exchange for nothing. Let me tell you what my judgment is. I am awarding you the $500 that you request for half of the money he got for publishing these pictures. Don't smile yet. Okay. I am totally disapproving of what both of you did with regard to invading someone else's, what I consider privacy. The fact that you are in your own car, even if you're out in a public parking lot, I don't necessarily believe that people who enjoy a certain celebrity have to feel as if somebody's going to come stalking around them and make money off of them, off of their private moments. So I am awarding you $500 from his $1,000. On your counterclaim, sir, that she called the police for no reason on you, I think that that's terrible, and I don't believe you had a reason to call the police.
There's more.
On him! Quiet. And I don't believe that you had a reason to call the police. So I am awarding you on your counterclaim, sir, $500, which means that you're even. Neither one of you gets anything. That's all.
Parties are excused. You may step out.
Britannia, Tabasco, Flutter, Humphrey. I feel so stupid here.
The case of the phony Beanie Babies.
This sweater has beady eyes.
I don't know diddly about Beanie Babies.
You buy it as is, when is, where is, with no warranty.
I know that you're an auctioneer, but please, give me a break.
All parties on Corder versus Dillon. Step forward, please.
Collectors Janice and John Corder claim auctioneer H. Matt Dillon sold them fake Beanie Babies. The auctioneer says he always gives a disclaimer at the beginning of the sale.
Order. All rise. Quiet in the courtroom, please. All rise. Ma'am. Judge, this is case number 303 on the calendar in the matter of Corder versus Dillon. Parties have been sworn in, Judge. You may be seated. Ma'am, have a seat, please.
Mr. and Mrs. Corder, you went to an auction that was being run by the defendant, and at that auction, according to your complaint, you purchased a bunch of Beanie Babies.
Yes.
Now, I've never seen any of these things, although I've heard about them, so you're going to show them to me, of course. And your complaint alleges that you purchased these as collector's items, you know,
yes, ma'am.
Rare Beanie Babies. You purchased them as rare Beanie Babies because the defendant here said that they were rare Beanie Babies.
Yes, ma'am.
And they turned out to be ordinary Beanie Babies.
No, fake.
Fake Beanie Babies.
You want all of them?
No.
And you want your money back.
That's right.
He says, he gives a disclaimer at the beginning of every auction that he's selling them for what they are. You get a chance to look at them, get a chance to touch them, smell them, taste them, feel them,
no, ma'am.
Whatever you want before the auction, and he sells them as is. So that's what this is about, right?
That's correct.
Part of it is correct. We were not allowed to see them. Well, we saw them through a glass case. We were not allowed to touch them until after they were paid for.
Not correct.
Okay.
Well, what do you mean not
So that's
correct?
shut.
not
Don't talk to him. Don't talk to him. Talk to me. So, first, is this the first auction that you went to?
No, ma'am.
No.
You go to these auctions regularly?
We've gone to quite a few, yes.
And you are collectors of Beanie Babies?
Yes.
How large is your collection of Beanie Babies?
Oh, we probably have, without these, probably 100. Not old like this, though.
How long have you been collecting?
Maybe 6, 7 months.
Why do you collect them?
Well, Mainly because they're valuable, and my daughter sold one for $1,025. We have a friend who sold one for $3,000.
Could I see all of them?
Sure.
Yes, ma'am.
So what are the usual conditions when you go to an auction?
It does say, yes, as is, where is. But it's what you say is what you have. You know, you
What do you
can't
mean what you say is what you
If
have?
you say you have a saw, it better be a saw, not a hammer. And if you say you have a hard-to-find Beanie Baby, that's what it is. Not one that's 6 months old and totally fake.
Okay. So tell me how these Beanie Babies were sold. You have the ad?
Yes, ma'am, I do.
I haven't seen the ad.
Okay. There was 2 ads in the Kansas City Star for an estate auction. The other one was listed in antiques and collectible section. They were both in the same paper.
Okay, let me read them. Okay. The part that you're referring to is plus several older, retired, hard-to-find Beanie Babies.
Yes, ma'am.
Includes Britannia, Tabasco, Flutter, Humphrey, and several others. All right, so let's try to identify these, because this is maybe where you made your mistake, sir, if you made a mistake at all. Among these Beanie Baby, now you can give them all back, because I'm going to ask her to hold them up. Among those,
thank you,
Miss Corder, do you have a Britannia?
No.
No. Do you have a Tabasco?
No.
Do you have a Flutter?
Yes.
Can I see the Flutter? That's the Flutter.
Yes, that is a Flutter.
And do you have a Humphrey?
I had a Humphrey and I sold it.
One that you bought from him?
Yes, ma'am.
So that the Flutter, the Humphrey, excuse me.
Yes.
I feel so stupid here. The Humphrey that you bought from Mr. Dillon.
Yes.
Was an authentic Humphrey.
I don't know. I hope so.
But you sold it as an authentic
Yes,
Humphrey
ma'am.
to somebody else.
Yes.
And what did you pay for that Humphrey?
Humphrey. $575.
That's what you paid for it?
Yes, ma'am.
And what did you sell it for?
$1,400.
We better get a Humphrey, Judge.
I better get right. You better get a Humphrey. You're absolutely right. And you sold it for $1,400.
Yes, ma'am.
Now, what did you pay for this Flutter?
$385.
Okay. Now, I'm going to explain to you what I'm ruling on the rest of the items that you bought.
Mm-hmm.
He advertised in the paper only specifically certain items that were real.
Mm-hmm.
In the second ad, he said, selling several older, retired, hard-to-find Beanie Babies. And clearly, based on the fact that you sold at least one that you bought
yes,
at a profit of $900.
Yes, ma'am. Yes.
Right? You got nothing to complain about there. He also says in several others, which is what you're complaining about, that these 4 or 5 that he advertised were older and retired ones. And of all of these, the only one that you have a complaint about is Flutter.
Yes, and it's fake.
And you say the Flutter is fake.
Yes, ma'am.
Okay. Now, how do you know the Flutter is fake?
Because this Flutter has beady eyes. I can show you in the book that he quoted for every Beanie Baby, the price, that Flutter does not have beady eyes.
Well, let me see it.
Okay.
Let me see it, because Mr. Dillon, you see, part of your mistake was to specify what you were selling. Because when you, for instance, let's say you are selling jewelry. I will just make a comparison to jewelry, because I don't know diddly about Beanie Babies. I know a lot about jewelry. And let's say you put in this ad that you were selling estate jewelry and diamonds. Good quality diamonds, top quality diamonds. But then you got specific and you said you were selling a 2.77 VS1 Sea Clarity diamond. And it turned out that it was a diamond that was all full of spots and carbon, and more carbon than diamond, right, then you would have been in trouble, right?
Right.
Janice and John Corder say auctioneer H. Matt Dillon falsely claimed the Beanie Babies he sold them were authentic. Matt says they should sue the original owner.
So that's the only one. I only have a problem so far with Flutter. You want to say something?
Yes, I sure do. Yes,
Okay.
I sure do. You know, I'm an old auctioneer, been in this business a lot of years, done over 3,000 sales. They say they've been to a lot of sales. Before every auction, you know, I work with a lot of attorneys, I do a lot of estates, work with a lot of municipalities, police departments. I know, yes, I understand. But anyway, before every sale, through legal advice, we're told to do our full disclaimer. And we do, and I do a full disclaimer before every auction. Now, she contends that she could not see these Beanie Babies. This lady had a right at any time to pick them up, look at them, handle them. Now, we locked them in the showcase so somebody won't steal them. That's the only reason they're locked. Now, when they come out of the showcase, I sold them over a period of time. And again, she had the right at any time before I sold it to walk right up where I was sitting on top of this platform selling to say, let me see this Beanie Baby. Not one time did that woman come up there and ask to see anything of any of these Beanie Babies.
Because I was told no. Whoa.
I listened.
No, don't.
I stood and listened.
Okay.
Not one time did she come up and ask to see them. Now, in my profession, we tell everybody you buy it as is, when is, where is, with no warranties applied of any kind. What you see is what you get. You take it just like your husband or your wife. You take it home, you love it forever, and call it wherever you want to call it. That's just the way everything is sold in the auctions. And we also, on all of our flyers, everything, we state, and Your Honor, be glad to see it, we print on every flyer, and it's laying right there at the sale for her to walk up and look at any time. It says, any statements made day of sale takes precedence over printed matter.
Well, let's
it's
see what it
stated
says.
right there at the auction.
Let me see what it says.
Yes.
Well, my response to this, sir, is as follows. Right down here in the bottom, in the smallest print on this entire flyer, you say, statements made the day of sale take precedence over printed matter.
Correct.
Okay. People are drawn to your auction, and I understand your position, but I'm telling you, the way you get them to come there is by your ad, correct?
That's correct.
Not by the flyer, because they're there already when you get the flyer. You draw them into your auction based upon print.
Correct.
Right? She came there because you specifically advertised, sir, several, by name, Beanie Babies. If you had just put in the ad several retired Beanie Babies, the ad would still be legitimate. Technically legitimate, because you had some old ones, you had some new ones. You went a little further. You, with specificity, named the old and retired ones that you were selling. And I just have to see whether this one that she bought was actually old and retired. So now you're going to show me the book.
I also have the paper from the internet that shows the real and fake, or shows what's wrong with them.
Let me just see it.
I also brought another one simply so you could compare the eyes. This is not one I bought at his auction.
I don't.
But it has a different type of eyes, so you can see what the eyes are supposed to be.
Says Flutter there.
Down at the bottom and then the next page. In the book, you cannot see the eyes.
Description. Fake Flutter.
Flutter.
Here's the book also.
Authentic Flutter is left. Counterfeit Flutter is right. Oh my God.
When I get a chance, Your Honor, I want to give you the origin of these, which will prove these are original.
Okay. Okay. Her main complaint is the beady eyes. Now let me hear you, sir.
Okay. on the Beanie Babies, on the marking, both from the Schroeder's, which is a very well-known antique collector's deal. We took a page out of it. And also this magazine we picked up here, which is an authority supposed to be on Beanie Babies. The right markings you look for that tells you how to actually identify, and it's based on ear tag and tush tag.
So let me see
and
it.
It'll tell you.
Let me see what you have.
In here. Right there. This tells you the first ones, second ones, exactly how they should be on the ear tag. And you come back here and it tells you exactly how they should be marked for the tush tag. And then I got one more bit of information here that I want to give you. We contacted Customs to find out what does constitute a counterfeit, and Customs give us this right here. We pulled it off the internet. They told us where to pull it up at. That actually tells what a counterfeit is. A counterfeit is any Beanie Baby bought in China, brought into America, because Thai does not recognize that. Even though it's original Beanie Baby, if you don't buy it through Thai, they call it a counterfeit. I mean, we're telling you, this is the facts.
They're all facts.
If I buy Chevy out the back door, it's a counterfeit.
I know that you're an auctioneer, but please, give me a break. It's early in the day. Well, certainly based on what you have in this book, the tag, what you call the tush tag.
The tush tag is the back one, yes.
Is certainly legitimate.
Right.
Maybe. Maybe.
Beanie Baby collectors Janice and John Corder claim they were sold fakes by auctioneer H. Matt Dillon.
Mr. Dillon, how many of these did you sell?
I sold 18.
How many of these?
Oh, one.
Just one?
One. There's one of each.
Okay. And as far as you're concerned, this is authentic?
As far as I'm concerned, it's authentic, yes.
Good. You just bought it back.
Your Honor, could I say one more thing?
Sure.
Okay. She bought 6 out of 18. That means there's 12 more went out of there. I contacted one of our customers, which is a good Beanie Baby dealer. Of course, I saw him out of the Beckon, not that book, never heard of it before. But anyway, I contacted the one. He's done sold his. He says they're authentic. They're good. No, everybody's happy. There's the only complaint I had is right here. Yeah, he made a big profit on them.
The fact that the ad said several others does not mean there are several they did not name.
Well, now I'm going to come back to you, and you're going to be really sorry you asked me that question.
Well, probably.
Yeah, you are. Because
Thank you.
You said something before to me that was really telling with regard to our Humphrey Beanie Baby. And that is that you bought it for $500, you sold it for $1,400, which
Yes,
means you
ma'am.
made a profit of $900.
Yes, ma'am.
And I said to you, was it authentic? And you said, I don't know, but I hope so.
Yes, ma'am.
Which means that, and I don't know who this person is that you sold it to.
No, but with conscience, I have to find
Just
that
a second.
man.
You sold it.
Yes, ma'am.
To somebody else.
Yes.
And I am certain that this somebody else, unless they were just released from an institution, did not pay $1,400 for this piece of stuffed nothing, right? Unless you indicated to them that it was an authentic Beanie Baby.
Yes, ma'am.
And you weren't sure.
No, but if you look at the picture that...
You weren't sure.
No, ma'am. Well, at that point, I was sure that it was real. I had no idea they were fake. None whatsoever. But now I know they are.
Now, all right, let's assume, madam, for the purpose of argument, that's true. And I'm not so sure I believe you, because it was, according to you, it's very easy to tell whether this was fake or real, because all you had to do was look in a book, because you say, you could see, it's right there.
No.
The eyes,
In
the
book,
eyes.
you can't see the eyes.
What?
In that book, you can't see the eyes.
In the book that you gave me, you can't see the eyes?
No, ma'am, you can't. You can't tell that they're not beads.
If you're telling me that I can't tell that, then how are you giving it to me to prove that this is a fake?
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY.
Mr. Dillon, this is your business, sir?
Yes.
You like happy customers?
I love happy customers.
Good. And you think that this is an authentic Beanie Baby?
I think it's authentic.
Good.
The man that sold him was willing to give her money back.
Yes, he was.
Just a second. Well, that's absolutely terrific. So what are we all doing here?
Because when I filed my lawsuit, I was also told to file a complaint with the Better Business Bureau and the Missouri Attorney General's office, which I did do. When It all came about with the man who brought him to Mr. Dillon, said he would return my money.
Yeah.
That he told Mr. Dillon from the start, if anybody has any complaint about any of the Beanie Babies, I will gladly refund their money.
So
Mr. Dillon here tells me he has the money and he will give it to me when I kiss his butt and write a letter stating that I overreacted and should not have filed any kind of claim or charges against him.
Well, let me ask you this question, Ms. Corder. Now I understand that there is certain animus
Yes.
in addition to everything else. Did you file your complaint with the Attorney General before or after you sold Humphrey?
After.
Give him his Beanie Baby. He wants it back. He's going to sell it and make a whole bunch of profit. So you're just buying one back. As far as the others are concerned, it's